The Federal Live-in Caregiver program is, as mentioned earlier, is actually the only program under the temporary foreign worker program that has a pathway to permanent residence. Under this program, Canadian employers can hire a foreign worker to come to Canada and work in their households, providing care to either an elderly, an individual with disability, or a child. This program, however, has 4 conditions, and all workers coming in, they have to comply with these conditions, otherwise they lose status, which would affect their eligibility to apply for permanent residence, and would eventually lead to a removal order being issued against them, and finally to their deportation. So the conditions are: 1, the work permits issued under the program is actually employer specific. So caregivers can only work for the employer on their work permit. If they work for other persons, that's an authorized work. Second, there is the living requirement. They have to live with their employers in the households of their employers. They get 2 days in a week as time off, but basically their residence is their place of work. If they live outside, again, it's a violation. Third is only caregiving. So providing care to persons I've already mentioned, vulnerable persons. They can do some like minimal household chores and things like that, but technically that is not their jobs. They're supposed to provide care. And if that is not shown when they apply for permanent residence, then their eligibility is at risk. The fourth is they have the duty to maintain their temporary status, meaning they should be renewing their work permit before it actually expires. Now, the work permits issued, they have expiration dates. And whenever they have to change employers, either they're being let go by their employers because the employers have no longer financial capability to, pay for them. Every time they do that, they have to get a new work permit before starting their new jobs with the new employers. If they start working before the work permit is issued, that is an unauthorized work. Now, these 4 conditions under the program, they actually expose the workers to abuse and exploitation, not only by the employers but also from recruitment or placement agencies. Now, first thing, the employers. The fact that their status is tied to the work permit. The workers are actually forced to take on whatever abuses that they encounter in their workplace. Since they live with their employers, there's a blurring of lines between personal hours and work hours. It effectively places them on an on-call basis. So supposedly they're only to work 8 hours a day. But since they live in their employer's house, sometimes they're on call. Let's say, the child that they're taking care of wakes up at night, they have to be there because they are the ones supposed to be taking care of that child. Then there's also this idea that since you are living in their household, you act like as a family member. Family members chip in, right? But the thing is, these workers are actually, they're there as their employers. They're covered by employment contracts. They don't need to be treated as a family member. What is required is that they be treated with dignity just like any other human beings. That is the requirement. However, most of the caregivers' experiences, if not all actually, is that they work long hours. They're not paid overtime pay. Some of them don't even get days off. They're required to work during weekends or any holidays and no payment for that. Worst cases, there's sexual and physical abuses from the employers. Now, since their status are tied to the work permit, they don't really report all these things to the government. They can, technically, they can file a complaint with the Ministry of Labor, but they don't do that. Mostly because they just want to stay and finish the 24 months as fast as they can so they can be reunited with their families. So they just stay there and take on the abuses. There's actually not a lot of cases reported to the Ministry of Labor from caregivers. There used to be a hotline with the Ministry of Labor, but now it's gone. For some reason, that's actually unknown. So there's no hotline anymore. Now, with recruitment and placement agencies, supposedly, with the passage of Bill 210, which is an amendment to the Employment Standards Act, recruitment agencies are not allowed to charge caregivers or workers for their placement fees for their services. But this is a provincial law, because the employment is a provincial law. This is only effective in Ontario. What's going on right now with recruitment agencies is actually they charge the fees outside of Ontario, even outside of Canada, which becomes a jurisdiction issue for criminal laws. So we're going around it. And what happens, they usually charge about between $3,000 to $5,000 US for their fees to find employers. But what happens is that when the caregivers arrive here, then they find out that actually there's no job waiting for them because the employers actually do not exist. So they get in trouble either at the border with CBSA, which is the Enforcement Agency of the Immigration Department, or they get in trouble when they get here because they don't have a job and then they can't restart the 24 months to comply with the requirements of the program. Now, the fact that the worker status are temporary, it also affects their ability to access services or benefits here in Canada. They are technically covered by OHIP, but only if they have valid work permits. During the time when they are in between jobs and do not have a valid work permits, they cannot access OHIP. They are also technically, they can apply for EI, employment insurance, when they don't have jobs, but that's only if they did not quit voluntarily, because that is the eligibility for employment insurance. But if you are being abused, some of them would actually choose to leave their employers. But between that time when they're in between jobs, they don't have resources, financial resources. I mean, they can access welfare, but that's actually really bad for a permanent residence application, because that means they are financially inadmissible to Canada and their application will be refused. So those are the things that limits the caregivers. I mean, in terms of access to benefits here in Canada. Now we're talking about permanent residence as well. Yes, they do have a pathway to permanent residence, but there's so many obstacles in between. First thing that I would like to highlight is the processing time for you to be reunited with your family. We're talking about family reunification here. First of all, before they can apply for permanent residence, they have to put in 24 months to complete the requirements. That's already 2 years. For those people who are lucky enough to finish it within the first 2 years of their arrival in Canada, they put in PR application. Processing time of PR application at least takes another 2 years. But most people actually cannot finish it in 2 years. The 24 months, finish it in 2 years. Some of them will take 3, 4 years. And then on top of that is the processing time of the permanent residence application. What does that mean though? In terms of family reunification, there's a very long time when you're separated from your loved ones. What happens is this breakdown of relationships with spouses, even with your kids. Some of them do eventually arrive here. You have children who do not even recognize their mothers. Majority of the workers under the live-in caregiver program are actually women, 95% of them. 5% of that are, only 5% are men. Then we also have limitations on the caregiver's ability to upgrade their skills. During the 24 months, caregivers are actually not allowed to take, not allowed to go to educational institutions unless they get a study permit from CIC, which limits their ability to go to school, aside from their long hours, which actually they won't be able to go to school anyway, even if they have a study permit. So what what I would also like to highlight is that most women coming here are actually highly educated from back home. Some of them are nurses, some of them are teachers. But when they get here, because of the lack of the limited access to skills upgrade, they end up doing caregiving jobs for many years, even after they're done with the program. What happens is that most of them are the financial providers of their family back home, and they try to reunite with their families. And so when the families get here, they depend on these women to provide for them financially. And so the workers actually do not have the financial capacity to even upgrade their skills. They get stuck in caregiving jobs for many, many years. What I would also like to talk about is what I want to talk about more is that the LCP, the Living Caregiver Program, is actually facing changes right now. I'm sure that you've heard of the comments from the Immigration Minister, Chris Alexander, and Jason Kenney about coming changes. Now, we don't know when that's going to take effect. We also don't know how it's going to look like. The hints, however, is that it will affect the pathway to permanent residence. They're talking about maybe changing it into something that looks like the Canadian Experience Class, which is actually very difficult. It has a very high standard in terms of language capability, which most of the workers under the LCP will not be able to meet. We also have Chris Alexander saying that, the government has a legal obligation to give permanent residence to caregivers. What does that mean? It's always been the case, though. The burden is on the caregivers to meet the requirements of the program, and then CIC will say, okay, you qualify. Sure, that's our obligation now. But right now, there's about 60,000 caregiver applications pending for many, many years. And we're not even talking about the people coming in. The changes that's going to take effect will actually affect the people coming in. And the worry is that the people coming in will not even have a pathway to permanent residence. They will just be temporary worker for years and years. And the other concern, which already been mentioned earlier, is the 4-in, 4-out rule, which is going to take effect in April next year. That would actually lead to many workers here currently with legal status becoming illegal because they will not have any ability to renew their work permits. Once the work permits are expired, even if they have employers who are willing to continue their jobs, they'll lose their status. And that would actually end in my time's almost done. But anyway, just like a quick thing. The workers, thousands of workers losing their status in Canada would actually end up in a huge detention enforcement by next year. Now, detention is a different thing that would be a subject for a different conversation. Immigration detention right now is also being challenged as actually a violation of human rights. And there's a current opinion that's recently been issued by the UN saying that Canada actually detained migrants arbitrarily and indefinitely. And so that's the other issue that we are anticipating next year.